I believe we're good to go. It's 4 p.m. So good afternoon, everyone, and welcome to a very insightful and important webinar with the Ministry of Finance and the International Center for Settlement of Investment Disputes, or ICSID, as we'll be referring to it throughout the session. This is Sultan Hatoum from Abu Dhabi Chamber of Commerce and Industry, and I'm honored to be moderating this workshop today with the presence of His Excellency Yunus Haji Al Khouri, the Undersecretary of the Ministry of Finance. His Excellency had a vital role in the increasing efforts of spreading awareness of the Center, its importance, and its key role in resolving disputes between investors and states. And that's in line with the UAE's vision of forming strategic partnerships with international parties to elevate the country's competitiveness and position as a secure and safe hub for investing and doing business. We are also delighted to welcome from ICSID Mr. Paul-Jean Lecanu, a senior counsel and team leader, and Ms. Randy Ayman, a legal counsel at the Center, who will shed some light in today's webinar on the investor-state dispute settlement. They'll provide an overview of ICSID and will walk you through how to bring a claim before the Center, and most importantly, explain the relevance of ICSID to the UAE business community and its investments abroad. Before we start, I would like to bring into attention that we are streaming this session in parallel in Arabic as we speak via the link that the team just shared in the chat box, and that we'll have the last 15 minutes of the session dedicated for your questions. So please engage with us and feel free to submit your questions in the Q&A box at the right bottom of your screen, where Paul and Randy will try their best to answer as much as possible of it towards the end. So without any further delay, Your Excellency, I want to thank you again for your time today, and we're all looking forward for your opening speech. I'll pass it to you. Thank you.
Thank you, Sultan. I want really to take this opportunity to welcome all participants and organizers in the second workshop to be held in the UAE, which this time is a joint organization of Ministry of Finance and ICSID with the cooperation of the Abu Dhabi Chamber of Commerce. After the first successful workshop that was organized with Dubai Chamber on the 27th of July 2020, attended by 147 distinguished contributors in the workshop. I take this opportunity to thank Mr. Paul-Jean Lecanu, ICSID Senior Counsel and Team Leader, and Mrs. Randy Ayman, ICSID Legal Counsel and the Abu Dhabi Chamber for organizing this event, where it is organized through video conference due to the COVID-19, and will form an essential part of the Ministry of Finance commitment to enhance the existing cooperation with ICSID, and Ministry of Finance will spare no time and effort to transform this cooperation into a strategic partnership. As you may know, ICSID is the world's leading institution devoted to international investment dispute settlement, which was established in 1966 by the Convention of the Settlement of Investment Disputes between states and nationals of other states. ICSID offers administrative support to state and investor-to-state proceedings concluded under non-ICSID rules and provided administrative assistance. Together, investment disputes would usually be subject to national legal systems. In this context, ICSID has registered 745 cases under the ICSID Convention and additional facility rules. It is worth mentioning that the UAE has been a member of ICSID since 1982, and so far has signed 96 bilateral investment treaties. Until June 2020, UAE have ratified 86 treaties. Today, the key objective and the main purpose of this workshop is to allow the audience and the contributors to be familiar with ICSID rules and services. It provides for reconciliation and arbitration of investment disputes between investors and the state. It will provide deeper information about the procedure of registration of the dispute and cases, where they exceed would refuse the registration of a request for reconciliation proceedings. Issues related to breach of contract and its relations to the basic agreement of the bilateral investment treaty and the impact of the umbrella clause on the state obligation toward the investors. Thank you.
Thank you. Thank you very much, Your Excellency, for your introduction, and thank you, Mr. Hatoum, as well, and to all the distinguished participants who have joined us this morning. Welcome to this webinar. So my name is Podron de Canu. I'm, as Mr. Hatoum was saying, I'm a team leader and senior counsel at ICSID, and work with a team and supervise about around 60 investment cases. My colleague with me, Randy Ayman, is also a legal counsel, and she works both on cases and institutional matters. Before we start, we would like to thank the organizer and our host, the Ministry of Finance and the Abu Dhabi Chamber of Commerce, for organizing the event and inviting us to speak today. So the topic of today's presentation is the resolution of disputes between investors and states at ICSID. And here is our roadmap, so to speak, for this morning's webinar. First, we'll give you a brief introduction to investor-state dispute settlement and tell you what it is and why it is important for international investments. Then we will have a look at ICSID to give you an overview of its role and its relevance in the settlement of investment disputes. Then we will explain how investors can bring claims before ICSID, and give you a few illustrations, a few examples of how that works. And then we'll have time for questions and answers. But feel free as we go to enter your questions in the chat box, and we'll do our best to answer those questions as we go. So we thought we would start with an example of a case. It's actually the first ICSID case which was based on an investment treaty. Investment treaties are the main source of consent to investment arbitration. So Asian Agricultural Products was a company based in Hong Kong, which at the time was still a British concession. AAPL, so Asian Agricultural Products, owned a Sri Lankan company which operated a shrimp farm. And in 1987, AAPL alleged that its investment in that shrimp farm business had been destroyed during a military operation conducted by the security forces of the Sri Lankan government. And AAPL claimed that it should be given compensation for the total loss of its investment. And to resolve its dispute with Sri Lanka, AAPL chose to initiate ICSID proceedings on the basis of the UK-Sri Lanka bilateral investment treaty. So that's an example of situation that will give rise to an ICSID case. Now, I think it's important to keep things in perspective and to see the connection between investment dispute resolution and the promotion of investments. And the idea is that one way to promote and protect international investments is precisely to have available mechanisms that will allow you to resolve disputes between the host states and the foreign investors. And so we're briefly going to look at the different options that you have on the slide. The first mechanism is let's say an interstate mechanism. So the investor's claim is taken up by the investor's home state with the host state in order to resolve the dispute. If you will, the home state espouses the claim of the investor against the host state, and that is referred to as diplomatic protection. Now, you have to bear in mind that there are a number of requirements to be met in order to be able to invoke diplomatic protection. Requirements having to do with nationality, also the exhaustion of local remedies, and that's an important time factor to have in mind. In addition to that, diplomatic protection also depends on the home state's discretion. So the home state of the investor doesn't have to resolve the dispute, and the interest of the investor and the interest of his home state do not necessarily align. So it may be that the home state chooses not to pursue the investor's claim, which would leave the investor without a remedy. The second option is, and we're all familiar with that one, is to take the dispute before the courts of the host state. Now, one of the downsides in an international context is that one side will be unfamiliar with the judicial system of the host state, and there's an argument that there will not be a level playing field. In addition to that, there may also be a perception that the courts of the host states may not be impartial, and again, I'm talking about perceptions, or may not be sufficiently equipped or specialized to address the investment dispute. So a third option is to bring the dispute directly before an international forum to seek compensation, and that's the idea behind ISDS, whose primary purpose is to promote international investment and an international cooperation for economic growth. The attractiveness of this option lies with the fact that it creates a level playing field. It also depoliticizes the dispute resolution process, and it gives an opportunity to the parties to choose experts to resolve the dispute. Now, I've just talked about international investment agreements. One key concept in investment arbitration is that of consent. It's been described as the cornerstone of ICSID arbitration, and all that means is that both the investor and the state have to agree in writing to resolve their dispute, either by arbitration, conciliation, or mediation. And that consent is found in three different types of instruments: international investment agreements, as I said, and nowadays about 75% of ICSID cases of claims are based on international investment agreements. But you also have foreign investment laws. A state can consent to ICSID arbitration in its domestic investment law. And also investment contracts. There can be contracts which contain arbitration, ICSID arbitration clauses. Now, if we look at the rights briefly, the rights and obligations that you will find in international investment treaties, you have two different kinds of provisions. You have substantive provisions, such as those you see on the screen: expropriation, fair and equitable treatment of investments and investors, full protection and security. And you have procedural provisions. And these ones refer to the provisions in which consent is given to ICSID arbitration, or more broadly, investor-state dispute settlement. Those dispute resolution provisions usually refer to a number of rules, essentially three main sets of arbitration rules. You've got, of course, the ICSID Convention. You also have the ICSID Additional Facility, and you have the UNCITRAL arbitration rules, so the rules of the United Nations Commission for International Trade Law. And ICSID is the only institution that can actually administer cases under all three sets of rules. States are free to draft these procedural provisions as they wish, and they can, for example, add certain steps such as mediation, for example, before arbitration. And I'm actually going to show you an example now of a treaty in a few moments. We also wanted to give you a bit of context and show you why investment arbitration has been on the rise for the past 2 decades. If you look at the number of treaties and the evolution of foreign direct investment on the slides, you will see essentially 2 things. One, the number of international investment treaties has risen from about 400 in the 1980s to over 3,400 today. And the vast majorities of these international investment agreements include dispute settlement mechanisms, including ICSID arbitration. In parallel, you see also that we've seen a major increase in foreign direct investment. It has about approximately quadrupled over the past 20 years. And so we see that this combination of more foreign investment and more investment treaties, contracts, also in laws referring to ICSID arbitration, has resulted in an increase also in investment arbitration. That's something that Randy will show you just a bit later. The UAE has signed a significant number of BITs, bilateral investment treaties. We have put on the slides figures from UNCTAD, but you heard the Undersecretary this morning giving us even higher figures. These bilateral investment treaties are the most common source of consent. You have, broadly speaking, you have bilateral investment treaties between 2 countries, and you have also multilateral investment treaties involving more than two countries. And approximately 60% of all cases are based on bilateral investment treaties. I was telling you a bit earlier that pushed the wrong button. I apologize. I inadvertently clicked on a link, and it seems that my presentation is not responding at the moment. If you just give me a minute, I will try and fix this quickly.
No worries, Paul. If you want as well, we can try if Randy can, if she has a presentation, if she can share the content, we can promote her internally to be as presenter as well. Do you want to try this, or you prefer to take a minute?
I think I'm opening it now. I'm very sorry about this. It was it was an unfortunate mistake. Yeah. Can you see the presentation?
Yes, yes, we do.
Perfect. So let's go back to where we were. And again, I apologize for this slight glitch. And I think we'll go now straight to the overview of ICSID, not to be too delayed. Please, Randy, you have the floor.
Thank you, Paul-Jean. Good morning, everyone, or good afternoon. So we will now turn to ICSID. We will give you in this section an overview of what ICSID is and what it does. The picture in front of you, you can see the original text of the ICSID Convention. That's actually the book that the states sign with the very fancy ink you can see as well on the screen, and when they come to join ICSID. Next slide, please. So what is ICSID? ICSID is an international organization that was established by the ICSID Convention, also known as the Washington Convention. It's an international treaty that was negotiated by the World Bank executive directors and the World Bank member states in the early 60s. The convention was adopted in 1965, and it created the center, established the center the following year in 1966. So ICSID is one of 5 World Bank Group institutions, IDA, IBRD, MEGA, and IFC, while all the others institutions have a primarily financial role. ICSID is the only institution that is exclusively devoted to providing services in international in settlement of investment disputes, and that includes arbitration, conciliation, and mediation. So when states established ICSID, they had a number of goals in mind, but the main one was to boost the economic development of host states and mobilize a larger flow of private international investment. And they decided to do so by providing an international facility where disputes between investors on the one hand and states on the other hand can be resolved impartially. So ICSID, having administered almost a large majority of all known ISDS cases, approximately 70% of the cases, ICSID is the world's leader in investment dispute resolution. So as Paul-Jean mentioned earlier, and we saw in a previous slide, there is a correlation between the foreign direct investment and the signing of international investment agreements. This correlation or this increase between FDI and IIAs has also resulted in a significant increase in the cases registered and administered by ICSID. As you can see on this chart, the numbers has quadrupled since the 1980s. So over the last 20 years, there has been a significant increase in the cases registered by ICSID, either under the convention or the additional facility rules. I'm good. So ICSID is an international organization, and so it has, and it's truly global thanks to its 155 member states. These are the ones that are marked in blue on the map in front of you. The ones in yellow are the states that have signed the convention but have not ratified it yet. In terms of newcomers, Djibouti is the latest to join ICSID. It actually joined last month in July 2020. So in terms of conditions, there are no conditions to join ICSID except being a World Bank member, and there is no cost to join or to maintain membership in ICSID. Next slide. So focusing on the UAE has been an ICSID member state since January 1982. And regionally speaking, all countries in the Middle East and North Africa are ICSID member states, except Iran and Libya, and you can see the list on the screen.
Now, we're going to look now at the reasons why investors and states choose ICSID to resolve their investment disputes. There are a number of reasons. The first one is that, and perhaps the obvious one, is that it allows individuals and legal persons, companies, to have direct recourse to arbitration or conciliation against the states. And so we sometimes forget it, but this elevation of individuals and companies to the international plane was a major innovation when it was done in the 1960s, and that's really a distinctive characteristic of the ICSID system. Now, in addition to this innovative dimension, the ICSID Convention was also designed to maintain a very careful balance between the interest of investors and the interest of host states. And one of the procedural translations, if you will, of this procedural balance is that proceedings can be instituted by investors and by host states. And the convention provides for the possibility of filing counterclaims as well. A third reason is also that ICSID proceedings will result in a final and binding determination of the dispute between investors and states. And I'll say a word about the enforcement system also in a minute. Fourth reason, and that's also a very important one, the ICSID system can be described as autonomous or self-contained. Essentially, that means that the question of the seat isn't relevant in ICSID arbitration. Parties will not have to go to courts of a third country or unfamiliar jurisdictions because this system is self-contained and autonomous. All post-award remedies are administered by ICSID. And so, for example, if we were to compare this with international commercial arbitration, set-aside proceedings have to be brought before the center. The center will constitute what we call an ad hoc committee, which will rule upon the application for annulment. Fifth reason, which is also a very important one, it's the enforcement mechanism that the convention has put into place. The convention has put into place a simplified system with a high rate of voluntary compliance. The convention essentially requires member states to recognize the binding character of ICSID convention awards and to enforce these awards as if they were judgments of their own domestic courts. And so that means that parties have access to a network of 150 states where the award will be enforced. And this simplicity and specialization as well saves time, money, and ensures predictability. Now, on the next slides, we have a quote which I think summarizes rather well both the goal of the ICSID system, the means to reach that goal, and also outlines the perspective of both the investors and the host states. So the goal is to promote international investment, the means by offering a neutral dispute resolution forum, both to investors that are rightly or wrongly wary of nationalistic decisions by local courts, and to host states that are rightly or wrongly wary of self-interested actions by foreign investors. And I think that captures this idea of striking a balance between the interests of the investors and the states, and create that level playing field. A quick word about other features of the center. We have a cost-effective and very transparent fee structure. You will find all the information on the website, whether it's arbitrators' fees, the institution's fees. Everything is there, and parties, have all the information they need to plan ahead. As I said earlier, ICSID is the only institution that can administer cases under three main sets of rules, which are the rules that you find in most investment treaties, or that you will find also in contract and laws. There is a full-time secretariat, so essentially you have a secretariat which takes care of the day-to-day administration of cases. And you have an administrative council, which is the governing body where the member states meet and vote on the budget or amendments to our rules. And finally, ICSID also gives you access to hearing facilities internationally, whether it's through our agreements with other partnering institutions, or through the network of World Bank offices throughout the world. And we have about 130 offices, so that allows us to cover all world regions, essentially. Now we'll move on to ICSID jurisdiction and how to bring a claim before ICSID. What's the scope? That scope is defined at Article 25 of the ICSID Convention, this little blue book here. And there are essentially 5 requirements. First, you need a legal dispute, which involves the violation of certain obligations. That dispute has to arise directly out of an investment, and Randy will say a few words about what an investment is. That dispute has to be between a member state on the one hand, and on the other, a national of another member state, so an individual or a company from another member state. And lastly, there has to be consent in writing. I mentioned earlier that consent can be given in a contract, it can be given in a law, or it can be given in a treaty. But it's very important that that consent be given separately and in writing. If you ratify the ICSID Convention, that does not amount to consent to ICSID arbitration. There needs to be consent in a separate document, so either a treaty, contract, or a law. And Randy is now going to talk about the notion of investment.
So we have been talking about investment since this morning, and we haven't defined it yet. And as Paul-Jean mentioned, this is the second condition to bring a claim before ICSID. So there is no definition of investment under the ICSID Convention. However, arbitrary tribunals have identified a number of criteria throughout the years in order to determine whether there is an investment or not in a particular case. So an investor has to make a contribution that could be in money or in kind or any kind of assets that should span over a certain period of time, and that makes the duration element. And this should also involve an element of risk. So these are the three main criteria, but some tribunals have also taken into account a fourth criteria, which is the contribution to the economic development of the host state. But again, the main three criteria in the usual ones are contribution, duration, and risk. Next slide, please. So on the other hand, investment is most likely to be defined in the instrument of consent, and that could be in the contract, in the law, or in the treaty. And as Paul-Jean mentioned earlier, usually the instrument of consent is invoked in a case is a treaty. So we'll give you an example here of the treaty between the UAE and Armenia, the bilateral investment treaty between both. They have adopted a common definition that is actually adopted by many other treaties. In this article, you can see that they adopted a quite broad definition of investment. So here they say that investment means every kind of asset invested by investors of one country in the territory of the other country in accordance with its laws, and then it lists and it gives a non-exhaustive list of examples of what an investment could be. Next slide, please. So an investment can concern a wide range of economic sectors as long as it was not excluded by the instrument of consent invoked. The pie you see in front of you and on the screen, that's it shows the economic sectors that have been invoked in ICSID cases to date. A large number or a large portion of that, as you can see, concerns the sectors in the natural resources industry and the energy sector. Next slide. As we mentioned, there are certain conditions that should be met in order to bring a claim before ICSID. We said that there must be a legal dispute arising directly out of an investment between an ICSID member state and a national of a member state. So the national can be either an individual or a company. If it's an individual, he or she must be a national of another member state. And that means that he or she cannot have the same nationality as the host state. So for example, a UAE or an Emirati national cannot bring a claim against the UAE before ICSID. The convention does not prohibit dual nationality, but again, the dual national cannot bring a claim against one of his home states. So an Emirati British national will not be able to sue the UAE before ICSID. The nationality of the individual is assessed at 2 times, at the time of consent and at the time of the registration of request. Next slide. A company can also be a claimant before ICSID, so the company must also be a national of another member state, and it's usually so when it's incorporated in a foreign country. The nationality when it comes to a company is assessed at the date of consent. However, there is an exception under the convention that allows a company to have the same nationality as the host states if two conditions are met. This is if it's under foreign control and the parties agree to treat it as a foreign national. And I pass the floor to Pooja again.
Yes, thank you very much. And so we will finish with the last requirement, which is consent in writing. I would just like to note that I saw a question on the chat, which I propose to address in just a few minutes, because we are close to the end of our slides. But I'll address that question. So this is actually all conditions are important, but consent is, I think, particularly important. We've said already that there can be consent in a contract, in a domestic law, or in an investment treaty. I believe the audience will be familiar with consent in a contract. That's the standard. It's a pretty standard way to agree to arbitration, to insert an arbitration clause in your contract, and that can of course be an ICSID arbitration clause. Now, the way parties consent under a domestic law or an investment treaty is a bit different. It's a two-step process. First, the state will give its consent in the treaty. And that's often referred to as a standing offer to arbitrate. And we'll see. I've said that before, but we'll have a look at a treaty clause in a moment. So the state gives its consent in the treaty, and then the investor has to offer. That's the second step. Has to offer that accept that offer in writing. So the investor can, for example, write a letter saying that it accepts the offer, or can do so in its request for arbitration. And it's only once you have those two elements, the offer to arbitrate from the state and the acceptance by the investor, that you have perfected consent to ICSID arbitration. And so if you look at this treaty, this arbitration clause from the UAE Austria BIT, you will see that it says, Article 10.2, if the dispute is not settled amicably, then the investor may choose to submit it for resolution, and one of the options is international arbitration at ICSID. And so you see here that's the offer that the state is making. The states are saying to the other countries' investors, you may choose to have recourse to arbitration, and the investor in turn has to express that choice. I have here on this slide an overview of the cases in which claimants from the UAE, so UAE nationals, have been involved. And what is interesting, I think, what is interesting to note are two things: the sectors in which those cases have been brought, and the instruments of consent. So I will start with the instrument of consent. We've just talked about this, and you will see that the overwhelming majority of cases are based on treaties, and particularly bilateral investment treaties. So I would say that cases involving UAE investors are very much aligned with the global caseload from that point of view. And it's also the case when you look at the sectors. You will see that the sectors are primary energy, so you'll see gas pipelines, construction, a lot of construction cases, and also two cases involving the telecommunications sector. And so these are really sectors that we also see in cases involving parties from different other world regions. What's interesting to see is that if you look at the cases in which the UAE have been respondents, there have been fewer, only four cases, but these cases also involve the construction sector. So it's quite clear that, and I think everybody knows that that the UAE and UAE companies are very dynamic in this sector and a few others, and that is reflected in the cases as well. Now, to finish, before we start taking questions, because I see we've reached question time, I'll just say a few words about the outcome of cases. And I recognize that all of a sudden we're giving you a lot of information and percentages, so I'm going to break this down for you, perhaps. If you look at all the cases, you'll see that approximately 65% of cases are decided by the tribunal. They reach a decision. In 35%, in the remaining 35%, the cases are settled or discontinued. And so this is what you have here on the slide, but divided up in categories. If we look at the cases that have been decided, so these 65%, you will see that there is pretty much an even split between the cases in which the tribunal has upheld the claims of the claimants, and the cases in which the tribunal has rejected those claims. And so I find this information interesting to show that there are balanced outcomes, so to speak. The system has, some may have said, is not skewed in favor of one or the other. It's more an even split between claimants and respondents. And with that, I will conclude our presentation, and perhaps I can take the first question. There was a question about whether ICSID would consider adjudication clauses in ADR. It's actually a very topical question. Because ICSID is currently amending its rules, and all of its rules, so arbitration, conciliation, and we are also proposing a whole new set of mediation rules, because we've seen a sharp increase in interest in mediation. You see that that mediation is referred to more and more in investment treaties, and parties seem to be willing to explore mediation a lot more. And the advantage of mediation is that it can take place at any time, before, during, and even after the arbitration. Although under the ICSID system, it's not really that necessary given the enforcement system. But that, yes, the answer in short is yes. We are exploring that, and ICSID has a role in ADR. So I don't know if there are any additional questions. What about emergency expedited procedures? That's also an interesting question. I would say there are two aspects perhaps to that question. Expedited procedures and emergency on the other end. I was talking about the amendment project. In the context of that project, we have proposed an expedited arbitration procedure. And the idea is to allow the parties, if they so choose, to expedite the proceedings to reach a resolution faster. Now, if the person who asked the question, Dr. Jamal Chaikuni, is thinking of emergency, the role of the emergency arbitrator, that's something that ICSID has not put into place in the context of investment arbitration. What we've seen is that emergency procedures may give rise to situations in which one side, in particular the state, may not necessarily have time to prepare meaningfully for the proceedings. What we do have, though, is a system of provisional measures, and before the tribunal is constituted, the parties can already ask the Secretary General to put into place a calendar to address their provisional measures, so that when once the tribunal is constituted, it has the papers before him and can rule on the request more quickly.
Thank you, Paul. Thank you, Randy. Actually, I've received a couple of questions on the private. I want you to bear with me. I'm not a technical guy, okay? So I have a question here, which is like kind of have 3 or 4 questions embedded to it. So I'll start with the first one. Could the claim be submitted to arbitration by an investor if it is submitted to the local court?
So the ICSID arbitration is designed to be an exclusive remedy. That's the first point. You will also find you may also find specific provisions addressing that topic in the treaties. So it's always important to look at the treaty. And finally, I would say a third point is that you will have to verify that we are actually dealing with the same claims, so same basis and same parties, because that will have an impact on whether an investor or a party can go ahead with its claim.
Okay, so I believe now in that case, the second part of the question might not be relevant anymore because it says, can such a court review the merits, blah, blah, blah. So you said it's a sole,
yeah, that will depend on the answer to those 3 questions.
Yeah, exactly. So the last part of it, what are the institutional rules and conditions for the ICSID for registering a case of the claimant against the respondent? We've kind of covered part of it, I believe, during the presentation, but...
Yeah. Randy, do you want to take that question?
Sure, I'm muting myself. So yeah, the main conditions to bring a claim before ICSID, we said that there must be a legal dispute, and then that dispute must be arising directly out of an investment. They should verify that it's between an ICSID member state and a national of another country, of another ICSID country. And the last one is that there should be consent by both the investor and the state against which the claim is brought. So that's for the conditions to bring a case before ICSID and under the ICSID Convention, and also all the other conditions that might be included in the instrument of consent as well. As for the institutional rules, in the ICSID booklet that Paul-Jean showed a bit earlier, this one, you have a part called institutional rules, and there it is listed how a claimant or an investor, or if it's the state, but how a claimant can bring or can submit a case before ICSID, with the request for arbitration being the the main document to be submitted, and there they should list all the conditions we refer to are actually met, and they should submit a couple of other documents, including the power of attorney for representing if they have a counsel or an external counsel. So all the conditions are listed in this part of the booklet.
What I would add, perhaps, to this excellent description is that there is a registration process at ICSID. It's designed as a filter, if you will, to avoid frivolous claims. The bar is relatively low in the sense that we will not register if it falls manifestly outside of ICSID jurisdiction. So the idea is that each party who presents a claim, who files a request for arbitration, has to establish in its request for arbitration that it doesn't fall manifestly outside the scope of ICSID jurisdiction.
Thank you, Paul and Randy. We've received a couple of questions in the Arabic session. As you know, we're running this in Arabic with instant translation. So I'm going to translate to you one of the questions I believe you've already covered. So that's if one of the parties have already approached local courts, and the answer is no, they can't go to ICSID. Correct me if I'm wrong, because it's based on its sole merit. Right?
Yes,
okay.
Speaking.
Yeah. And the second question is, what are the guarantees on executing the resolutions arrived at from the arbitration?
So yes, that's something that I touched upon, the enforcement mechanism. Essentially, the convention provides that once there is an award, that award is final and binding and has to be executed. And that's why I was referring earlier to the high rate of voluntary compliance, because that's in the convention, and parties have to comply with it, and that's been efficient. And it's only in a minority of cases that there has been litigation with respect to enforcement. Now, what can happen, and that's separate, if a party files an application for annulment, that party can request at the same time a stay of enforcement during the proceeding. But that's something that the committee in charge of ruling upon the application for annulment will have to look at and rule on.
Okay, cool. Thank you. I believe you can see the questions that we are receiving now in the Q&A box. If not, I'm gonna anyway. I don't know if we have enough time to go through all of them. We've received like around 9-10 questions in addition to what we've asked. So the second question, Paul, what are the ICSID annulment mechanisms and the difference between the unicentral model law and the difference between the commercial and investment treaty?
Okay. So UNCITRAL has adopted a number of instruments. We referred earlier to the UNCITRAL arbitration rules, which was designed originally as a set of ad hoc rules that any party could use in an arbitration. You can find these rules in investment treaties, and ICSID administers cases under these rules. Now, the UNCITRAL model law is different in the sense that the UNCITRAL model law is a law that each individual country will use as a model or source of inspiration to draft its own arbitration legislation. So the references that you will see in the treaties will usually be to the UNCITRAL arbitration rules and not so much to the UNCITRAL model law.
Thank you, Paul. One more question on, I don't know how flexible you are on timing as well as His Excellency, but we're receiving several questions. I believe a good option would be, Paul, if you don't mind, if we can share those questions with you off records and get as well answers on it so we can share it as well with the audience. But I'm going to take one last question or two questions, if you allow me. It depends on your timing and your flexibility.
We are as flexible as you are.
Okay, good. So what are the circumstances under which the arbitral tribunal under ICSID provisions would hold that the claimant's investments no longer enjoy protection under the bilateral investment treaties agreements, BIT agreements?
There are several scenarios. It would be a bit difficult to explore them all this morning, but I can give you a few examples. Randy was referring to the notion of investment, for example. If it turns out that what the claimant describes as an investment doesn't qualify under the treaty, then that claimant and its alleged investments would not be protected by the treaty. You also have clauses in treaties, for example, that may allow, under certain conditions, that may allow the host state to deny the benefits of the treaty. So if these conditions are met, then the investor is not protected by the treaty. And of course, if the tribunal comes to the conclusion that there have not been any violations of the substantive obligations placed on the states in the treaty, then that's also a case in which the claimants would not be protected and able to claim compensation. I mean, I do realize that this is a bit, this is discussion in the abstract, but these are examples of situations in which a claimant would not be covered under a treaty.
Cool, thank you. I believe I'm gonna take one more question, one last question, for the sake of your time, the audience, and His Excellency, and we'll share an additional questions with you off records and get answers to it. So I've went through this, and probably you'll get it better than me. I can't see what is the question in specific, but probably it's because how it's been phrased. So if an investor claims that he had been deprived of substantial benefit of his investment and suffer significant economic losses because of government regulation under the state of police power without giving rise to state disresponsibility because of public health, unlegitimate and bona fide exercise of sovereign state police power. So I believe the question would be, what would be the case? What will happen?
Well, so that's I think it seems to me that the case that is outlined here is that of a situation in which an investor alleges that it has suffered harm, and the state, on the other hand, is invoking its right to regulate in certain sector. I think you gave the example of health. That's something that the tribunal will have to assess on the facts of the case. It's very difficult to answer that question in the abstract. The tribunal may come to the conclusion that the actions of the states were justified and proportionate, or on the contrary, may come to the conclusion that they were not, in which case the state might be held liable. But that will depend essentially on the assessment on the facts of the case. It could go either way.
Okay, I'm a bit curious before we close on now we you know, COVID have disrupted everything around us. We're having a program running at the chamber called Chamber Talk to discuss the topic. So have you noticed an increase in cases during the last couple of months because of COVID, or it's something like just have disrupted everything but the cases?
Well, what we certainly have noticed is that a steady flow of cases. We have been extremely busy during the COVID period. That has to do also with you know, a number of changes that have been made, and an increase in the number of virtual hearings. We had virtual hearings in the past, but now that number has shot up clearly. And that requires a lot of work. As to invoking COVID in the context of cases, I think we have seen one or two references so far to COVID in new or current cases, but what may happen, and again, I'm not, I don't have a crystal ball, so I can say for sure. But what may happen is that we may see this a bit later, in the sense that, for example, we were talking about treaties. A number of treaties will contain clauses that provide for a 6 months cooling off period, during which the parties have to try and agree on an amicable settlement. And so between the moment where the disputed facts arise, and then the beginning of that 6 month period, and then the actual filing of a request for arbitration, there may be a certain period of time. And so we would have to check again in a few months to see what is happening.
Yeah, I can tell from what we've covered in the chamber talk before. We had a session on force majeure and COVID-19, and I can expect that the new cases you referred to kind of linked to force majeure. And from what I've got, my understanding, it's kind of something. It should be something impossible for you to abide by the contract. So I don't know how this will go. It would be something interesting. We'll catch up after this to know, just from curiosity. I want to thank you again, Paul and Randy, for your time today. I want to thank as well the audience. Thank you to His Excellency for his time to join us on this session as well, and he's been a sponsor for this. And I look forward for future collaboration with you on future webinars. Thank you, and have a good day.
We would be delighted to do that. Thank you very much, Sultan, and thank you to the Undersecretary and to all participants.
Thank you.
Thank you. Have a good day.
You too. Thank you. Bye-bye.
Bye.